Good evening, ladies and gentlemen, and welcome to tonight's special program of the American Heritage Scholarship. Thank you for being here with us tonight. Those of you that are not familiar with the Downey Auditorium, take note of the exits in case there's, for whatever reason, we need to exit. The restrooms are in the back along with water fountains back there. My name's Tom Chagnon, and I'm the County Superintendent of Schools for Stanislaus County. And it seems only appropriate that as we have this wonderful program tonight talking about our great country, that we would stand and do the pledge. So won't you please stand and help me honor the United States of America. Ready? Begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. In your program, you will note a brief summary of the history of this scholarship program dating back to the events of September 11th of 2001. And you can read about that and how this program arrived as a result. You also see below that the prompt for this year, and we are excited to hear the presenters as they discuss this particular essay prompt. And we thank all of you for taking time from your busy schedules to be here with us tonight. We know that all of you are busy students, and it's not just the scholarship money opportunities for you, but I've talked to several who are here because they came to hear the discussion between our two esteemed presenters tonight. So thank you for doing that. So the Stanislaus County Office of Education is pleased to partner with this great event with Modesto B and Modesto City Schools, and all of our community sponsors are listed in your program. Please take time, and if you have an opportunity to acknowledge them at any time in the coming year, please do so. So the students, this is how it works. You know that the community members and students are invited to hear this presentation tonight by our distinguished guest speakers, and students are then invited to write and submit essays on focusing on this prompt. This year's prompt is in your program, and we are extremely fortunate to have an illustrious group of local educators, newspaper editors, and community teacher volunteers who spend their time to read and score the initial group of essays and narrow the field to the finalists. The top 10 essays are then forwarded to Rebecca Fleming of the Stanislaus County Superior Court, who coordinates the final reading and ranking, which is then done by the Superior Court judges. So it's important for you to understand that scholarships and awards will be distributed based on available funding. We'd like to thank Kathy Habeas in the audience with us tonight, who has helped to fund through generous sponsors much of the scholarship money this year, as well as those listed in your program that have contributed to this great cause. We need community members and educators to read student essays. And if you're interested, please see Brittany Boone for more information regarding this. So I would like to thank and introduce the partners along with the SCO on this, and the superintendent of Modesto City Schools. Ladies and gentlemen, a round of applause for Ms. Pam Abel. And the editor of the Modesto Bee, please welcome Joe Kita. It's my pleasure to introduce Joe at this time. Joe is the Modesto Bee's editor and senior vice president. And prior to joining the Modesto Bee, he was the executive editor of the Columbus Ledger-Inquirer, the McClatchy-owned daily newspaper in Columbus, Georgia. And previously, he had served as the top editor of the daily newspaper in Utica, New York, and Merced. Joe graduated from the University of Toledo, where he majored in history and minored in print communications. While he was editor of the Merced Sun-Star, that paper won a National Public Service Award for its series of stories illuminating wrongdoing by Merced's district attorney. Ooh, that was a scandal uncovered. The Sun Star also earned the first place General Excellence Award from the California Newspaper Publishers Association. So ladies and gentlemen, a big round of applause for Mr. Joe Kita.
Thank you, Tom, for that wonderful introduction. And it's just really great to be here today to see all of you. This is something that we really look forward to every year at the Bee. We really like to highlight the great work that students do in our community. We do a lot of it with athletics, but we don't do enough of it, I don't think, with academics. And this is a way for us to really highlight some of the incredible work and also give out a scholarship. So you really don't want to listen to me talk today. I'm going to introduce our two incredible guest speakers today, two real luminaries of the local legal scene here. First is Kirk Mcallister. Mr. Mcallister received the Bachelor of Arts from Stanford University in 1966 and his Juris Doctorate from USC in 1969. He was admitted to the California Bar Association in 1970. Mr. Mcallister served in the U.S. Army from 1970 to 1972, where he was a captain and prosecuted courts-martial. He also served for over 10 years as a deputy district attorney in Stanislaus County, and also with the title of senior trial deputy. Since 1977, Mr. Mcallister has been certified as a specialist in criminal law by the State Bar of California Board of Specialization. On September 28, 2007, he was honored at the California State Bar Convention for his 30 years of service as a certified criminal law specialist. In 1983, Mr. Mcallister joined the law firm of Zuckerman, Hartman, and Walden as its civil litigator, and in 1986, Mr. Mcallister established his own law office, concentrating on criminal defense and civil litigation. Mr. Mcallister has taught evidence at CSU Stanislaus. He has twice served as president of the Stanislaus County Criminal Courts Bar Association and has served as a director of the Stanislaus County Bar Association. Since 2007, Mr. Mcallister has been listed in California Super Lawyers. Mr. Mcallister was inducted into the American College of Trial Lawyers in 2008. He is a published author whose book has been hailed by one commentator as the Swiss Army knife of criminal trial practice. In 2009, he served as an adjunct professor at the University of Santa Clara Law School, where he taught criminal law. Welcome. Our next speaker is Ruben Villalobos. A graduate of Modesto High School, the Honorable Ruben Villalobos has practiced law since 1998, previously serving as both a Stanislaus County Deputy Public Defender and an Assistant Federal Public Defender for the District of Nevada. He tried over 150 jury trials and has authored briefs that have been argued before the Ninth Circuit Court of Appeals, as well as the California and United States Supreme Courts. A graduate of the Martin Luther King Jr. School of Law at UC Davis, Mr. Villalobos received the American Jurisprudence Award for Business Associations, as well as the Lorenzo Patino Award for Pro Bono Legal Service to the Latino community. Before law school, Mr. Villalobos spent a year starting an AmeriCorps program in the Bay Area after earning his bachelor's with honors from UC Berkeley in Ethnic Studies. While at Cal, Mr. Villalobos co-authored a poetry textbook. From 2009 to 2015, Mr. Villalobos served on the Modesto City Schools Board of Education. He also serves on the Board of Doctors Medical Center. In 2012, he was appointed by Governor Brown to the Stanislaus County Fair Board and also was a member of the 2012 Electoral College. And then, in December of last year, Governor Brown appointed him as a judge on the Stanislaus County Superior Court. So welcome, Ruben Villalobos. Thank you.
Yes, sir. All right, ladies and gentlemen, can you hear me out there? I think so. Looks like it's working. So I'm going to go ahead and start this off, and then Mr. Mcallister will be taking over. We'll go through the program, let you know who's going to be doing what. For all of you, I see that you're attentively listening. I know that some of you are taking notes. This PowerPoint presentation will be on the internet in the next few days. And also, for those of you who want, a little bit later we're going to have an open discussion, and I'll ask two of you to come up, preferably two of you with good handwriting, better than mine or Mr. Mcallister's, and we'll do a little group exercise. So those of you who want to be scribes, you could think about this. So I thought this would be a good way to start. Who remembers Michael Vick? Show of hands. Do we have the microphones live yet? Where's Brittany? Right here. Can someone raise their hand and tell us what happened in the Michael Vick trial? Right here. Or not.
Michael Vick was an NFL starting quarterback for the Atlanta Falcons, but was found guilty of conducting a dogfighting ring and was sent to jail for 2 years, I believe. Was it?
And what is your name?
Waleed Khan.
I know you, Waleed. How are you? And where do you go to high school? Where do you go to high school?
Minnesota High School.
All right, thank you. So the whole purpose of this slide is to show Mr. Vick probably wouldn't be fairly tried before a jury of his peers if those peers were all dogs because of the dogfighting. Who do we have today? I'm going to be speaking next. Mr. Mcallister will be speaking. And then more importantly, just like Waleed just did, each one of you will be able to participate by adding to the discussion, all the while thinking about what your essays will be involved. An overview of what we're going to be doing. First of all, just like I did last year, I'm going to go over the prompt with you. We're going to go word by word through the prompt. We're going to look specifically at what the prompt is asking for to help you formulate what you would be doing in your essays. Next, Mr. Mcallister will be giving a historical perspective on the right to trial and how it developed, the jury trial right, from the Magna Carta. Actually, I said to the present day, he's going to be doing it to the birth of our nation. And then I will take off from the Bill of Rights to the present. And then we'll have our group exercise where we can discuss the pluses and minuses of the jury trial system. So you can start thinking about that. What's good about a jury trial? What's bad about a jury trial? That is, in essence, what the prompt is, and we'll discuss that as a group. If we have time, we'll do a comparative analysis. We'll look at other countries. We'll look at the jury trial right over different times. And then we'll talk about some current issues as they involve jury trials. As far as questions, feel free to raise your hand if you have a question. We're going to see if we can figure out this feedback situation, get you a microphone. I think Mr. Mcallister and I both believe that your questions will only help to formulate the discussion and help you to get your thoughts together for the essay that you're about to write. So let's talk about the prompt. In 1215, the Magna Carta affirmed a right to trial by jury. 800 years later, and a continent away, many civil and criminal disputes are still resolved by juries. Is trial by jury an idea past its prime? Make a case either for or against the use of juries to try civil and criminal disputes in modern America. Now, I almost hesitate to try this again, but I want to try the mics again. We're good on the feedback, I hear. And my question for you is, what are the important phrases here? What is this prompt asking you? So I'd like you to raise your hand and say a couple of words. Wait till you get the mic. There comes one right there. Say your name, what school you're from, and then say an important word or two.
Michael Hildebrandt from Johansson. Make a case either for or against the use of juries.
All right, so it's a persuasive piece. You're arguing one way or the other. Good point, Michael. Who else? Let's see some hands. I know that you guys, so there we go, right there. Your name?
I am Connor Dysart from Johansson High School.
All right.
And this prompt is telling me to discuss the issues or benefits of the trial by jury and list them to either give why we should continue using trials by jury or get rid of them or replace them with judges.
All right. Also true. Good point. So I'm going to go ahead and take over from here, but I want you to start thinking about points where you can join into the conversation. This is the prompt deconstructed, and both of these gentlemen had some really good points. So I noted that first they talked about in 1215 and then 800 years later and a continent away. So just by there, we're talking about the evolution of a right, both in England at what they called at common law, moving over into the states, in the colonies, and then once the United States founded, there's an evolution of that right. We also can compare that, since we're talking about a continent away, we can compare that with rights in different countries. Furthermore, as one of the gentlemen mentioned, is the jury trial idea past its prime? In other words, there's a specific question that you need to answer in the essay, make a case either for or against the use of juries to try cases, and then also the issue of civil and criminal disputes. So as I read the prompt, that is how the prompt can be broken down to kind of cover all the bases. So in other words, going over that, there's a historical analysis, a comparative analysis between countries. You have to make sure to take a position, make the case and support that position, and of course, the civil and criminal application. And with that, I'm going to turn it over to Mr. Mcallister, who will be giving the historical approach from, again, the Magna Carta to the birth of our country, and then I'll come on back. Mr. Mcallister.
Thank you. Good evening, and feel free to ask questions at any time. How do you try a case? How do you decide, let's say, if somebody's guilty or not? Well, let's go back to England in the 1200s. There weren't judges everywhere, and so people who were actually witnesses to things would come together and tell the judge whenever he rode into town what had happened in a particular situation. That ended up being called a petty jury, which didn't decide anything. It just told the judge what, like witnesses would do, I saw this or that. Cases were tried by ordeal. Ordeal was, for instance, you would decide if somebody was guilty or not by giving them putting in their hand a red-hot poker. And then if they didn't get burned, they were innocent. Well, they got burned, and they were jumping around like Wile E. Coyote, but that was how they decided it. But the priest would come in and say, nope, the hand wasn't burned. And that would be how you would decide it. If the hand was burned, then they were guilty. Well, in 1215 was a big year historically. The Pope said at what was called the Lateran Council, no, priest, you can't do that anymore. Go back and do your priestly duties. You're not going to be this judge of who was burned or not burned by a hot iron or some of the other tortures they had involved. So now how would you try cases? Well, that's how the origin of the jury. They started being the ones who would decide cases. Okay, let's flip to 1215 again. King John, one of the most hated kings in England. After this King John, no king would ever be called John again in England. That's how much they hated him. True. And so the barons there, who were the, kind of the lords, had it with paying out money for all these foreign wars. And so they confronted him and said, these are our demands. And this was called, finally in history, the Magna Carta. And they forced him to agree to it, and then it got changed. He tried to back out of it later. It got changed over the years, but 1215, this was the Magna Carta. And this is the actual language from it. There are still documents, original documents of the Magna Carta in existence. I saw one in Boston a summer ago. But the important key words here were that no free man, and obviously this only related to not slaves, not people of color, but it was a start, that you would not be judged except by lawful judgment of your peers, that's a big one, or by the law of the land. And that later got recognized to be what we call due process. And so the Magna Carta then kind of fell into disuse. That was the year 1215. It got modified over the years, but it kind of fell into disuse, and it got to be kind of a thing once in a while the Englishmen would use when they were arguing over property rights, but didn't really get used in terms of arguing for personal liberties. Now, along came Sir Edward Coke. And I wanted to have a picture of him, but I didn't get a picture up of him. It's Sir Edward Coke, and it's spelled C-O-K-E, like Coke, like Coca-Cola, but it's pronounced Cook. Cook was the prosecutor for Queen Elizabeth. he was the Attorney General, and he prosecuted everybody who was important in all the political trials for Queen Elizabeth. So then she made him a judge. He became the most famous judge in England. And he revived the Magna Carta. He made it a vehicle to advocate for people's rights, people's liberty. And so, and he did that in a lot of different cases. And so he really revived it and almost reinvented the Magna Carta when he was a judge in England in the in the 1600s. Now we jump across the Atlantic to the colonies. As it turned out, the law books that Sir Edward Coke wrote were the things, there weren't law schools in the colonies. So how did they become lawyers? Well, they'd learn in somebody's office, they'd study in a lawyer's office, but for law books, Sir Edward Coke wrote a lot of books on the law. His law books were the things which informed the law students of that day. And again, he was arguing the Magna Carta as a source of human rights. This was a comment from John Rutledge of South Carolina. Thomas Jefferson learned from Sir Edward Coke's law books. It was the universal textbook for law students. Now, Sir Edward Coke argued about, he really, you've heard the phrase common law. This was a really important article with him because common law refers to more than one thing. Common was, finally the law was recognized across England to be uniform in all the various counties, so it was common to all the counties. But with Lord Coke, it came to be recognized as this historical body of law that started really in the Anglo-Saxon period, but was really codified or made a solid part of English history with the Magna Carta. And with it, he saw all sorts of rights which people had not previously recognized. So the common law was this thing that embodied natural law to him. This was really important, or would become really important, because I regard Sir Edward Coke as one of the founding fathers of the United States. Well, how can that be? He died, I think, in 1634, a long time before any of these. But his words lived on in his books and in the teachings that he gave to our founding fathers. And so the common law was this repository of rights. And he did one thing very important in a case. It was called Dr. Bonham's case, where he found that the natural law in the common law was violated by an act of Parliament. And as a judge, the Chief Justice of the King's Bench, he voided an act of Parliament. Now, that to us these days is not that startling, but it was incredible that a judge could overrule Parliament, and he did that based on his reading of the Magna Carta and the common law rights that were given to people, and to curb government when it outstepped its bounds. Now, you can see where these are some of the rights that immigrated to the colonies from his reading of the Magna Carta. The right to a jury trial, right to religious liberty, freedom from arbitrary punishment or restraint, the writ of habeas corpus you may have heard about originated in the Magna Carta, and the right to a speedy trial. Now, you can see where the colonists he was kind of the intellectual driving force of the colonists in a lot of the arguments that he had made years before, because the colonists started using his arguments about common law and natural law to say that, you know, the overstepping of its bounds by Parliament and by the King violated common law, and that under the precedent that he had set with this Dr. Bonham's case, that they could say, hey, wait a minute, that's void. We don't have to take it. This came up with some of the acts then that the government, the British government, was trying to use when they were trying to get their money back from all the defense they'd made at the colonies. It was used with the Stamp Act and with the Sugar Act. If any of you are budding historians, you'll know that those were some of the triggers that started the colonists resisting the British government. And so they used the arguments that Sir Edward Coke had made to make their points. Now, as far as juries, jury trials were well recognized in the colonial days. Then they kind of, you know, they didn't have a lot of law, history of law, so they would use some English law, and juries would actually decide what the law was. They wouldn't just decide what the facts were, way different than how we have it today. But one thing I would refer to you, and we've got a link to it. There was a very good PBS special on John Adams a few years ago. And one of the things that I liked best about it was that John Adams, who of course was one of the founders of the country, took on a very unpopular case in 1770 where 8 redcoats, British soldiers, had fired into a crowd in Boston. It's called the Boston Massacre, and killed 5 colonists. So they were tried for murder. And John Adams, although he was quite heavy into, and he and his brother Samuel, heavy into the resistance to Britain, took on the case to defend them. And they went to trial, and actually 2 trials, and they were all acquitted of murder. A couple of them were convicted of a lesser offense of manslaughter, but that was a lot better than murder, and for that they only branded their hand. And that was a punishment they did that day. If you ever see somebody being sworn in court, you know, you swear to tell the truth, the whole truth, why do you have your hand up? Well, that's because they would look for a brand to see if you were a felon. We have a lot of historical things still in our law that don't get recognized very much. But at any rate, John Adams said that, and it went to a jury trial, and he said at the end of his life that that was the act of public service that he was most proud of, to represent these redcoats in a very unpopular war. Now, tables had turned 4 years later. Now we've had the Boston Massacre. What happened now was the British government enacted a law that said that any trials of any British people, authorities, crown officers, etc., where are they going to be had? The British were afraid of jury trials. They're going to be had back in England. So that's a little bit of a history of the historical precedents. Then when the states started, the colonies started becoming states, the one constant in all the state constitutions of the original states was they put in there the right to a jury trial. So that is the one constant that we've always recognized. Sometimes it changed. It didn't mean that people of color could vote back then or be on juries, or women. Of course, it took a long time for a lot of the real changes to take place. But the core value has always been recognized in our history of the jury trial.
All right. Thank you, Mr. Mcallister. Round of applause for Mr. Mcallister. And he'll be joining us in another moment to discuss more of this. Before I talk about the right as it developed from the common law or from England, as it developed and it came over here to the United States, Mr. Mcallister mentioned a word that I wanted to talk about, and we discussed it quite in depth last year. How many of you were here last year? Raise your hand. We were at the Office of Education. Okay, so all new student. You were here, Mia, I remember. The phrase was natural law. Mr. Mcallister just mentioned the phrase natural law. All right, who has an idea of what that phrase means? Let's throw out some ideas. Let me see a hand. Right there. All right, was it, name again, was it Michael? Connor. All right, let's get Connor and Johansson, right?
Yes.
All right. So what does natural law mean?
I think natural law means like the basic rights that everyone has, like, you know, the...
Now, you're on the right track. Go ahead.
What to say? Stop. It's like, you know, life, like liberty, and like the pursuit of happiness or property, which was like stated in
Okay,
like
all right.
John Law.
So let's get some other thoughts. Natural law, what Connor said was it's the basic rights that everybody has. Your name, sir?
Miguel Guzman, also from Johansson.
Miguel, what more can you say about natural law?
I think it also means like rights given to us by nature.
By nature,
They're
okay,
part-
by who? Who gives us these rights? You said nature. Who else gives us these rights?
God?
All right, for some of us, it's God. For some of us, it's the fact that we're born. It's because the very reason that we exist, we have these rights. Another hand over here. Let's see this microphone. Your name, sir?
Tiandre White,
All right, and where are you from?
Grigori High School.
All right. And what did you want to say about natural law?
Natural law is given to everyone, and it cannot be taken away from anyone.
All right. So these are all the basic thoughts. Thank you all for those comments. And the reason I wanted to discuss those is when Mr. Mcallister was talking about the gentleman who basically undid an act of Parliament saying that government created these rules, that rule was undone because there are certain rights that cannot be taken away from us. I think you all did a very good job coming up with what in fact natural law is. Round of applause for yourselves. All right, so tying it into the development of the jury trial, the whole idea is that, like, say, for example, a few years ago when someone was prosecuted, who can mention, just throw out the name of a famous person who was prosecuted and went to trial? Some, right there. Yeah. Who? George Zimmerman. All right, that's a great example. George Zimmerman was prosecuted and he went into trial. Does everybody remember that? The gentleman who was charged with shooting Trayvon Martin, he did go to trial, did he not? I thought he did, yeah. So here's the question. Who said that he's either guilty or not guilty of that? Who made that decision? A jury. 12 people made that decision. A jury made that decision. If any one of you were charged with murder and had to go to trial tomorrow, who would make that decision if you asserted your right? 12 of your peers. Just statistically, all of you who are sitting in this room, once you become of age, if you're not already, once you become 18 years old to get on with your lives, you will sit on a jury and you will make a decision. You may have no experience whatsoever in the law. You may be a waiter, you may be a college professor, you may have never gone to school. You will be making that decision that determines whether or not a person is guilty of a crime for which they may go to prison for the rest of their life, a crime for which they may be sentenced to the death penalty. Why do people buy into this? Why do people accept this? Because they believe in the system. And so that's how the right developed, and these are the basically the origins. The first was the Sixth Amendment to the United States Constitution. The words are there, you can read them, but the highlight is that in all criminal prosecutions, people were entitled to a speedy and public trial by an impartial jury. Remember, Mr. Mcallister talked about the jurors originally were people that saw what happened. So say, for example, your next-door neighbor gets hit by a car and you happen to see it. Are you an impartial juror? No, you're not. You know that person. If you like that jury, that neighbor, you might be in favor of everything they have to say. If you don't like that neighbor, you may not be in favor of what they have to say. You're not impartial. The next right is that it's by a jury from the state and district wherein the crime shall have been committed. Trayvon Martin, raise your hand, you can say it out. What state was that? Where George Zimmerman was prosecuted? In Florida, all right? In Florida, they have something called a stand your ground law that we don't have here in the United States. It gives certain defenses, certain rights that an individual has to defend themselves if they are being attacked. And it's somewhat greater a right than we have here in California. Would it be fair for Mr. Zimmerman to be prosecuted by a California jury? No. because the right is that you need to be tried by someone from the state and district from which you live. The right to confront the witnesses against you. Before, when you were tried, that trial could happen in a back room. Today in other countries, trials happen in a back room. The doors are closed. You don't have the right to hear the evidence against you. You don't have the right to confront the person who is accusing you. So they have to look at you in the eyes when they say that you're guilty, when they say that you did something. That's another constitutional right. And finally, the assistance of counsel for his or her defense. All right, so in essence, we talked about those rights. They'll be in the PowerPoint so you can review them. Now, those were criminal cases. Now, in civil cases, because remember, going back to the prompt, that we talked about the evolution of the jury trial right, both in criminal and civil cases. Well, that's the Seventh Amendment. Now, I'm going to read this word for word, and then we're going to go over it a little bit. In suits at common law, where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact tried by a jury shall otherwise be re-examined in any court of the United States than according to the rules of common law. Big fancy language. What does it mean? It means that you have a right to a jury trial in a civil case too. What is a civil case? Who can raise their hand? Let's get a mic over here. Let's get a different hand. Thank you, Michael. Let's get a different hand. We heard from you too. Let's hear from some new people. I know you can do it. Here's the question. What's the difference between a criminal case and a civil case? Easy answer. I know you guys know this. A new hand, fresh hand. All right, right there in the back. Tell me your name, where you're from, and the difference between a criminal case and a civil case.
I'm Heidi, and I'm from Whitmore Charter, and I think the difference between a criminal case and a civil case is that a criminal is between the justice system and a defendant, and a civil case is between two individuals.
All right.
Or two groups.
All right, that's pretty good. That's pretty good. In a criminal case, it's between the individual who's accused of committing a crime and his or her government. Now, citizens may be involved as victims, they may be involved as witnesses, but it's between the individual defendant and his or her government. In a civil case, you said it's between two individuals. Sometimes it's between an individual and government. For example, if someone were to fall and hurt themselves here, they could sue Modesto City Schools. I'm not advocating that anyone does that, Superintendent Abel. I'm just saying that that would be between an individual and a government. Two governments can sue each other. Right now, the Modesto Irrigation District and the City of Modesto have been suing each other for 10 years. All right, and individuals can sue each other as well. So that's the difference between a civil case and a criminal case. Now, the $20, let's think about that. Does this say that any time someone rips you off for $20 and you want to sue them, that you have a right to a jury trial? Yeah, that's what it says. That's the plain language of it. But it's not true. And so the reason why, it's interesting, there have been entire law review articles on this. People at Harvard have written about this. And the reason why I wanted to mention that is because the founding fathers, the people that wrote this, they said they came up with this arbitrary number of $20. Anything greater than $20, you're entitled to a jury trial. Well, $20, by the way, in today's dollars, take a wild guess how much that is. Right there, just say it. $750, that's pretty close. It's between $500 and $600, okay? From when this was written to the present day, it's, by my math, about $500 to $600. Well, right now, even if your amount in controversy, as it is, if that you're suing is less than $5,000, and Mr. Mcallister, you know this better than me, that's generally going to go in a small claims court, correct? Yeah. So, in other words, it says that. It doesn't really mean that. Even when the founding fathers wrote it, they didn't mean it. It's a good example that if you get in the business of writing laws, write things that you mean and you stick with it. Because that right never really developed. Anything more you want to say on that? No. All right. So let's move forward. How did that get in there? Oh, since it's there, I think I have to say go Bears. All right. Superintendent Abel went to Cal. I went to Cal. Mr. Chagnon did not. Mr. Mcallister didn't. They went to Stanford. All right. Back to business. I don't know how that slide got in there. Also, Mr. Mcallister, that's a lesson that you want to make sure that, you know, the person who has final review on the slides, that was me. That's why that cow one went in there. Evolution of the jury trial rights. What developed here as far as those rights in the states? First of all, the right to a speedy trial. What do you think a speedy trial means? This is a community forum. I want to hear from you. Raise your hands. Tell me how fast you think a case should go to trial. Anyone raise your hand? All right, we'll come back to, what was it, Michael or Connor? All right, Connor, let's bring him the mic. Connor, what do you think about a speedy trial? How fast should a case get to trial?
Well, I think if it's going to be a speedy trial, then it should be addressed in about a few days to a week, and it should be finished within about 2 to 3 weeks.
All right,
at the
a
most.
few days to a week and finished in 2 to 3 weeks. I ask you a question, sir.
Yes.
Are you from Cuba by any chance?
No.
Let me tell you why I ask you that question. This is a true story. I was in Cuba in 2002 or 2003. When I was there, literally on the day that I got there, a bank was robbed. Now, banks don't get robbed in Cuba, but one was robbed on that day. Say that was a Monday. By the Wednesday, the individuals had their trial and were convicted. By the Friday, they had their appeal and the conviction was affirmed. I flew out on Saturday. Take a wild guess what happened on Sunday. The sentence was imposed, all right? Does that sound fair to you, Connor?
If they are already convicted, and
Yeah.
Imposed means that it was brought back again?
Imposed means that they were sentenced, and by the way, the sentence was a death penalty. They were executed. All right, killed.
Well, I don't think that...
Microphone.
Okay, so I don't think the death penalty was fair, but I think they should give a little more time, because if in a few days, maybe not all the facts were released.
There you go. There you go. Maybe not all the facts were. We have a couple more hands. Let's bring them in. Thank you, Connor, for those comments. We've got a comment over here. We've got a comment over there. Go ahead. You've got the mic.
Hello, my name's Sarah Sorensen. I'm from Oakdale High.
Sarah from Oakdale. Go ahead.
Yes. I think it depends on the extent of the crime and how complicated the facts are presented to the jury and how extensive those are. It varies. As long, a speedy trial to me, what it means, conceptually speaking, is that all the facts of the case are being able to be presented to an unbiased jury and are then able to come to a conclusive decision on what the penalty shall be.
Okay. Let me take that. Those are all great points. Number one, all of the facts are presented to an unbiased jury, and they get time to come up with what the penalty is. All right. One little thing, that was a great answer. Round of applause right there. One thing I want to throw in for just a little technical correction. Generally speaking, it's the role of the jury to determine guilt or innocence. They don't determine punishment. Now, the exception to that rule is in capital cases. In death penalty cases, they first determine guilt or innocence, then they come back and determine punishment later. But what you said was exactly right. Those are all great factors. One more comment up here. Let's get the microphone. I think one of these gentlemen from Gogori, perhaps.
I'm Hyung Oh, and I'm from Gogori. And I just thought that a speedy trial doesn't necessarily have to deal with the amount of time, but that a speedy trial has to mean that after a thorough investigation has been done, then the trial is allowed to start. So, you know, like you talked about Cuba, you can't just do it in like 3 days. You know, after a thorough investigation has been
Right.
done, you're allowed to.
Great. All right, great job. Now, Mr. Mcallister, remember I told you that these young people would come up with the answers for us? They have. Look at this. Well, Barker versus Wingo, 1972, talked about the right to a speedy trial, okay? And again, when I write these down, Barker versus Wingo, 407 U.S. 514 972, I'm not super concerned that you remember that. You can find that on the internet. You guys all know how to Google better than I do. I think that there's one thing there I think is very important, aside from the case name. Who can guess what it is? What's the most important thing there? Waleed. The year, 1972. And I'm trying to move around so I don't have so much feedback. 1972, and the reason why that's important is because we show the evolution of a right from 800 years ago, all right, to the founding of our country. It was till 1972 before what a speedy trial was established. Now, there were 4 factors to consider to determine whether or not a person's right to a speedy trial has been violated. And you know what? Most of you got them right now. The length of the delay. How long was it? Are we talking about 2 days or 5 days? Are we talking about a week or 3 months? Are we talking about a year or 2? The reasons for the delay. Why did those delays happen? Were those delays because the defendant wasn't entitled to review documents? Was it because, Hurricane Katrina, you guys remember Hurricane Katrina? You think they might have had some problems getting people to trial in a speedy fashion when there was a lot of looting going on, when records were destroyed, when police officers and district attorneys and judges and defense attorneys couldn't make their way to court because they had to take care of their families? So the reason for the delay, the timeliness of the assertion of the right. Let me get a hand as to what you think that means. The timeliness of the assertion of the right. All right, go ahead. Microphone.
I guess in general, it means, a defendant shouldn't try to exercise that right in a way that they'll later be able to say that their right was violated. So using your example, if someone was waiting trial and then Katrina hit, and then they purposely asserted that reason, they purposely asserted their right, then they know that Katrina would probably delay the trial, so then therefore they would be able to sue the government for that.
All right, that could very well be true. That's a good point. Think about it in the context of your own home, all right? Say that mom or dad did something that you thought was really, really unfair. They took away your allowance. They said you couldn't have your cell phone, whatever the issue was. If you talked about that today versus you say, hey, back in the 6th grade when you did X, Y, and Z to me, I think that really wasn't fair, so I want back allowance for the last 4 years. Is that going to fly? No, that ship has sailed. That's what the timely assertion of the right means, that it be raised in a reasonable time period. And finally, the degree of prejudice caused by the delay. All right, let's think about some examples of prejudice caused by a delay. Say, for example, there was a situation where a person is charged with stealing a car, and there were 3 witnesses to that theft. And then all 3 of those witnesses died a year from now. Trial hasn't happened yet. 2 out of those 3 witnesses says, you know what? That guy didn't do it. Some other guy did it. Do we think that the defendant is prejudiced by that delay? He's not. These 2 witnesses aren't here anymore. Because he didn't go to trial or she didn't go to trial in a timely fashion, they were prejudiced by the delay. Do we understand that? Yeah. All right. So moving on. Assistance of counsel. These are some other rights that developed in regards to the jury trial. We're going to go about another 3 or 4 minutes here. I'm going to have you talk about pluses and minuses to jury trials, and we're going to wrap up. Assistance of counsel. Just take a wild guess. When do you think, again, in the Magna Carta is 1,800 years old. The country was developed in the 1776. The Bill of Rights was written when? I don't remember. 1783. When do you think the right to counsel, the assistance of counsel, was firmly established in United States law? Just let's see some hands. Shout it out, just so you could say it. 1900, 2000, 1876. What's that? 1900s is what I heard. 1983, 1800s. Well, let's figure it out. In capital cases, in death penalty cases, you did not have a right to have an attorney at your side assisting you at that trial that you had a constitutional right. Since the 1700s, you didn't have a right to have an attorney helping you out until 1932. In felony cases, so that would be not capital cases, not the death penalty, but other felony cases, your robberies and things like that, you didn't have a right to have an attorney at your side till 1983, and that was only if you were in federal court. If you were in state court, you didn't have that right till 1963. That was 10 years before I was born, ladies and gentlemen. That right didn't exist till 1963. If you want some good fodder for your paper, Google Gideon versus Wainwright. Look at some of the articles. There's everything from 50-page law review articles to 2-page documents to videos, movies. Gideon's Trumpet, I think, was the name of the movie on it. That really talks about the establishment of the right. If you want to find out when it changed in the United States, that pretty much if you were going to be going to jail, you have the right to the assistance of counsel. It was Gideon versus Wainwright. One more thing, I was just thinking, I want to go back and correct one of Mr. Mcallister's points because I think you'll appreciate this. He said that John Adams miniseries was on PBS. It was either on HBO or Showtime, so trust me, it's a lot more fun to watch. There's better language in it. So you can go back and watch that. All you can also do is just Google it, all right? It's a great movie.
One thing on assistance of counsel that's recognized now, at least, is not only that you have a right to an attorney, but that you have a right to an attorney of your choice. And that's an important right.
You have the right to an attorney of your choice, and that's an important right to Mr. Mcallister because he wants people to come hire him. It was an important right to me when I was an attorney in private practice because I wanted people to hire me. But more importantly, it's a right that you each and individually enjoy. If you were to be facing a criminal prosecution, you don't have to have an attorney forced upon you. You can get an attorney of your choice. You even have the right to have you for an attorney if you want. You have the right to represent yourself as part of that case law that developed on whether you have an attorney of your choice. We're getting late in the hour. I'm going to move forward through a couple of things, some issues that you may want to look into, you may want to Google, or unanimity, all right? So you have a right to a trial. You have a right to a jury trial in a criminal case and in a civil case. Do you have a right to be acquitted or convicted by 12 people? What about if 11 people think that you're guilty and one doesn't? What about, is it a majority? Is it 7 to 5? What about in civil cases? These are all areas for you to look into. Let's have a couple people come up real quick. I want to get through this because this is some really important, this will help you to write your essays. I need 2 people that can volunteer to write. Mia, right up here. Your name? Jasmine, come on up, right up here. Round of applause for Mia and Jasmine. Thank you, Mia. You can be right here. And Jasmine, you can go across. All right, so now, I know the hour's late. This hasn't been a very talkative audience, but we really need your help here. This is your portion. This is your time here. Mia, if you could write on the top a big plus and the word jury trial. Jasmine, right? Guess what I'm asking you to write? Big minus and jury trial. That's right. So, what are some reasons, and we're not going to wait for the microphone, or just shout it out and I'll repeat it so that way the people at home hear it. A reason why it's a good thing that we have jury trials. We've been through a lot of them today. Let's see a hand. Right there. So diversity in the jury, so that when people are hearing the case, there's a better chance that a biased person won't make the decision, but a group of the community will render the decision. Is that a summary of what you said? Yes. All right. So, in other words, what she says is she doesn't want Judge Villalobos deciding what's happening on her case. She wants a jury of 12 of her peers. That's exactly right. Good point. So, diversity on the jury. Other positives. Yes. Right. In a democracy, you're tried and convicted by your peers, not by the government. You can also be acquitted, by the way. All right? It could also go the other way. So we'll say it's a fundamental tenet of democracy. That's what the basis of democracy. All right? All right, other things, other pluses of a jury trial system. Yes? All right, it gives time to think about it. Time. Just built into it. You have to get those 12 jurors together. You have to prepare your defense. You have to get ready to present the case. It gives time for thoughtful reflection. Thoughtful reflection. There's a story that they teach you in law school. Let's put time there. There's a story that they teach you in law school where basically there was a story of, I think they call it the butcher, the baker, and and the candle maker. And the way it works is that the butcher said that the baker killed him. All right, no, that didn't work. How would he say that if he was dead? The butcher was killed, and he said, and the candle maker said that the baker did it. All right, and then there was no butcher around, and so he was convicted, the baker, of killing the butcher. About a week later, the butcher walked back in town. He was off on a fishing trip. All right, and so this person was convicted and killed, executed, because there wasn't that time for the thoughtful deliberation. I've already messed up that story. Let's move on. Right over here. Yes? Speak up. Various opinions and points of view. Yeah, just diversity of, let's put another check mark next to diversity of opinion. Some other good reasons for a jury trial system. Waleed. Less prejudice. All right, there's a quote that I was going to present to you. We're running out of time. It was a quote from Nelson Mandela. He was tried and convicted of terrorist acts some 40 plus years ago. I don't remember how long ago it was. And as he was addressing the court, he said, "Why should I believe in your justice system when everyone here has oppressed me? There's not a single black individual on the jury. Everyone were what they were called Afrikaners, the Dutch white ruling class. In a jury system, you have more people involved, you have diversity, less chance for prejudice." A couple more reasons why jury trials are good. Back, shout it out. I'm sorry, you hear that. Less chances? Less chance for an innocent person to go to jail, or for that innocent person to be executed, the ultimate punishment, right? So fairness, fundamental fairness. All right, one or two more. Right here. That's a smart answer. That's a great answer, to help the public to be educated about what their rights are. Do you know that all of our judges, and I'm a new judge, I've only been a judge for 9 months, but I've appeared before all the other judges, and when they talk to the jurors that come on, they like to talk to those jurors about what their rights are, about how you have the right to vote, and you have the right to go to the congregation, the church that you want to or not. You have the right to live where you want or not. And one of those rights are to participate in the jury trial system and be convicted or acquitted based on a trial of your peers. So to educate the community, it is the point. And the three things that we do, those of us who are not community-minded, the three things that we have to do are pay taxes. We don't even have to vote if we don't want to, but that's an option. And jury service. Those are the three real parts where we exercise our democracy. All right, any other pluses about the jury trial system? Yes? I'm sorry, it allows them to exercise their rights? To protect their rights, to exercise their rights. So we're going to put due process. I'm going to use the word due process there to cover that. All great answers. A round of applause for the pluses there. All right, now, on the other side, we've got Jasmine here, she's been waiting to write. She wants to write. What are some problems with the jury trial system? All right, right here, Connor, right? Okay, all right. I see what you're saying. You're saying that the attorneys have the right to sometimes kick off juries to stack things in their favor, all right? So in other words, and what's wrong with that? All right, so in other words, a judge, smart judge like Judge Villalobos, unbiased judge like Judge Villalobos, wouldn't be subject to that, right? So with the jury, you have the possibility they can alter juries, put the word bias after that as well. Great. Right here. Possibility of having unqualified members of the jury. All right. I disagree with you, but I'm going to put it up there. And let me tell you why. He says that there could be unqualified jurors. Okay? I think that a lot of people believe that. I think that a lot of lawyers believe that. I think that a lot of members of the community believe that. I think that I've tried 200 jury trials. I think of those 200 jury trials, That would be times 12 jurors minimum. I think that there were some that I didn't like as much because they voted against my client, some that I liked more because they voted for him. But the thing that's great about a trial of your peers is what I said earlier. If we look at our parents in this room, if I were to ask you what your parents are, I'll bet you that we have parents that are doctors, we have parents that are lawyers, we have parents like my mom who's a school teacher, we have parents that work in the fields, we have parents that are housekeepers, we have parents that don't work, that stay home. We have a diversity of opinion and thought in our community, and that's the purpose for a jury. I disagree with that, but it's a good answer, so we put it up. You all had answers. Another problem, next door with the jury trial system. Same thing, next one. All right, they all had the same answer, right here. That's great. I'm going to summarize that by saying jury apathy. If they don't want to be there, it takes down from the system. You know, they have Google, I shouldn't tell you this, but you probably already know it. You can Google how to get off of a jury, and there's all kinds of videos that tell you exactly what you need to say to get off of a jury. So because of people not participating in that democratic institution, there's a problem with it. Understood. Right over here, other problems with the jury trial system. All right. So just the fact that it's mandatory, that's a problem. The fact that it's mandatory. People have wives and husbands that they need to get home to. People have young children that they need to get home to. People have jobs that don't always pay them, in fact, often don't pay them to be on jury service. All right. And the other thing is, to my knowledge, I can't think of another area where you're compelled or required to do something by the government. We don't have a draft. You're not compelled or required to serve in the military. You are compelled and required to send your kids to school. You are compelled and required to not break the law, but you're right, just the effect on the individual as far as time out. Other thoughts, problems with the jury trial system? Right. You know what? Amen to you, brother. But you know, what if you're the 9-month pregnant woman that needs to do it? That's even harder, right? So absolutely, great points. Now, we're going to put that in there, just the effects on family, the effects on health, and that you have to do these types of things. And of course, there are excuses, reason you don't have to go to jury. I promise you, if you're ever in Stanislaus County Court, your wife is pregnant, 9 months, you'll be excused. I promise you that's going to happen. In the back, out loud so I can hear you. I can't. Can someone relay that up to me? Yeah. All right. So in other words, juries can be swayed. We can put that there. All right. Yeah. Through emotion. All right. Do I look like an emotional person, ladies and gentlemen? Do I look like I'm emotional? I tell you, I did 150 jury trials and I was talking like this. All right. I was emotional. I would disagree that juries can be swayed by that emotion. I think that you can help get your message across through that emotion, but it's a good point. Any other thoughts? Problems with the jury trial system? Right here, young man, your name. Right. Jury nullification. What is jury nullification, Anthony?
I'm not sure I can provide the best of this necessarily, but I was talking to Mr. Mcallister, Kirk's wife, recently about it, so I think he can provide great details.
You think he can do it better? That's a great answer. Mr. Mcallister, what's jury nullification?
Jury nullification is when the jury hears the evidence and they decide that maybe it's a bad law or they shouldn't be party to this prosecution, keep it a criminal case. And so they just say, to heck with the law or the facts, and we're going to find this person not guilty.
Or we're going to find this person guilty. It's when the jury nullifies the law or disregards the law to do what they want.
And it's an ancient phenomenon. It had happened long ago in England, and in one famous case, the king was so mad that he imprisoned the jurors, but a jury verdict is inviolate. You can't disrupt it even then. So the person was found not guilty. It was a rebellion, and but the jury went to jail.
Jury went to jail on that one. We won't be sending you to jail either. Go ahead.
We won't put that on the board.
Yeah. I'll get you next. Got it. I'm going to cut you short there because I got it. So 2 issues. The first is we're going to put racial challenges to the jury. And the basic summary is that everybody has a right to serve, and you can't be excused, you shouldn't be excused because of your race, because of your sexual orientation, because of your gender. That's the basic thought there. The second one was jury safety, or juror safety. As a judge, I'm not allowed to talk about current or pending cases. What I can talk about is general systems, things that have happened in the past. On occasion, courtrooms are shut down. You remember that constitutional right? You have a right to an open and public and speedy trial. On occasion, trials or portions of a trial can be shut down because you can have some very, very bad people. Not necessarily the defendant, but people who are convicted of being very, very bad people. That can be sitting in the courtroom, that can be testifying from the courtroom, that can be watching all the people who are testifying, that can be watching all the jurors, and theoretically, they could harm a juror down the road. So juror safety, I think, was the summary there. We're running out of time. A couple more. Waleed. Fair and unbiased juror. So just the time that it takes to pick a jury, right? All right, so we're going to put, it takes a lot of time. I think that's the biggest problem with the jury trial system. It takes a lot of time. Right here. What's that? A tie in the verdict. You can get a hung jury. Sometimes a hung jury happens. You had a comment over here. I said I'd come back to you. So juror safety and jury fear, we kind of talked about that over here. One in the back, out loud, please. Could someone repeat that? I can't hear. Lack of public agreement. All right, you mean lack of public agreement or support behind the verdict? All right, that's a great answer. That's a great point. So you could have a situation where a person is tried, like O.J. Simpson, for allegedly killing his wife, and he's acquitted. The jury said, we found that you did not, the jury didn't prove that you killed your wife. There was a lack of public agreement on that verdict. You know, a lot of people weren't too happy with that verdict, so that can happen too. Any more comments on the pluses or minuses of jury trials? The reason why I asked you, can we get a round of applause for Mia and for Jasmine? Thank you. Thank you. Go ahead and have a seat, ladies. The reason that I asked you, thank you. The reason that I asked you to have these discussions and to think about this is because this is what you're going to want to do in your essay. But remember, not only do you have to make a statement, you have to back it up. Jury trials are past their prime. It's an idea past their prime. Why? You say arguments for it. But then if one of your arguments is that, well, because there's a jury safety issue, well, shouldn't we just fix the jury safety issue, right? So you have to back it up. If you're looking at the other side, no, it's great that we have juries because of due process and to help educate people about their rights and fundamental fairness. What about the person who died? What about the poor mother or father that has to be home because, and deal with the fact that their son or daughter was murdered? How are they dealing with fundamental fairness? And if this has taken 5 years to get this case going, or 3 years or 2 years, and if there wasn't a jury trial system, if through a system of fair judges that could be adjudicated or resolved within 3 months, wouldn't it be fair to the victims? Now, the point, ladies and gentlemen, is that you are not lawyers. You have an amazing blessing right now, which is that as long as you make a solid argument and you back up that solid argument, you're not bound by any of these cases that we talked about. You're not bound by Koch. You're not bound by Jefferson. You're not bound by any of the cases that I cited. You can do whatever you think is right in that essay as long as you back it up. So I think what we're going to do is just ask if there are any final questions. The hour's late. Any questions? Yes. Some more information about that? Well, first of all, I want to tell you that Mr. Mcallister has a piece on the Magna Carta. I'm going to put a link to that on the PowerPoint. I'll get that to Brittany, and so you have a lot of stuff there about it, all right? The other thing, we didn't get to talk, we were going to talk a little bit about South Africa and the Oster Pistorius case, which was tried by a judge and not a jury. We were going to talk a little bit about the right to a trial in Japan, where that's tried before a judge and not a jury. And also, the defendant is presumed guilty and needs to establish their innocence, which is the reverse of here. There were things that we were going to talk about. We ran out of time, but you can Google any of that and incorporate that into your paper. Any other last questions? Right here. Well, that's a great point. I didn't see that in the prompt. I don't think you have to, but I think you just gave away your prize-winning essay idea to everybody else. Yeah, that makes sense. Don't be just a complainer, right? If you think this is a bad system we have, come up with a good other one to say why it's better that judges do it, or maybe, and here's something else. If you want a modified system, look to Sweden. I'll tell you what happens in Sweden. In Sweden, there's a judge who tries the case, and there are 2 jurors that decide in conjunction with the judge, and the majority vote of 2 or out of the 3 decides. The jurors are professional jurors in Sweden, all right? So they're, like, here we have judges and lawyers. There they have another element in the legal system, which are the jurors that do that for a living, in essence, instead of, as we do, we don't do it for a living. We show up because we want to make our $15 a day that we get paid for jury service. That's a great idea.
We could put up boards and do pluses and minuses on that system, too.
Yeah, exactly. There are pluses and minuses to what's going on over there. Any last questions? I'm excited for all of you. You're going to write great essays. Please tell your friends to watch the video. Thank you to our sponsors. I know Mrs. Superintendent Abel's coming up. She has a word to say.
Could we please give Judge Villalobos and Mr. Mcallister a big round of applause? And also, thank you to students and teachers and parents and community members for being here. And just take note of this, students. In the past years, many essays have been disqualified, but the majority is for a couple of reasons, so pay attention. If you don't want your essay to get disqualified, please remember the following. Quote and cite both of the speakers in your essay. Cite them in your bibliography page. And besides comments from the speakers, make sure you have 3 additional Supreme Court decisions and/or scholarly sources. Just some facts to date about this scholarship. 100% of donor contributions go to fund the student scholarships. The money dispersed since 2002 is $122,000. Award winners, 7 students have received scholarships, and the number of high schools involved has been 36. And some of the scholarship winners have gone on to college, and they've attended colleges such as Brigham Young, Sarah Lawrence, Stanford, St. Mary's of California, and the UCs and CSUs. Big reminder, the essays are due to the County Office of Education by 5:00 p.m. on Friday, October 16th. You may access a video of the lecture, which will be available sometime next week on the Stanislaus County Office of Ed website, which is www.stancoe.org, and you're going to look under the Programs tab. American Heritage Essay applications can also be found on the Stanislaus County Office of Ed website and the Modesto Bee website. And there are also many resources available that will help with writing this essay, including the essay rubric and a web tutorial on writing, which was produced by the Modesto Bee. So I want to thank all of you for being here this evening. Good luck to all of you, and have a safe trip home. Good night.